Good afternoon, everyone. Thank you for joining us. We're thrilled to be presenting a timely webinar, Curriculum in the Crosshairs, Race, Sexuality, and Free Speech in Schools. Sponsored by the ABA section of Civil Rights and Social Justice, this panel is one of many in a series of rapid response webinars. We're actively planning additional programming on a variety of issues, so please visit americanbar.org/CRSJ for updates on these programs. During today's program, we encourage you to please ask questions of our panelists through the Q&A, not through the chat function. If you don't see the controls, be assured that your screen is not idle. We'll address questions at the end of the program. I'll play cat herder on those. We'll be sharing a recording of this program with everybody who has registered so you can share it with your networks. And with that, I am thrilled to bring you this wonderful, wonderful lineup of presenters. It's not often you go out to recruit every one of your first choice speakers and they say yes right away, but we're so excited by the quality of this lineup, and you will be as well. Our panelists today are Tom Hutton, who is the Interim Executive Director at the Education Law Association, Talia Richman, who's Education Lab Reporter with the Dallas Morning News, Emerson Sykes, Senior Attorney in the Speech, Privacy, and Technology Project of the American Civil Liberties Union, and I'll be your moderator. I'm Frank LoMonte. I'm the co-chair of the Free Speech and Free Press Committee of the ABA section of Civil Rights and Social Justice. Before I turn it over, starting with Talia to speak to you about her experiences on the ground covering these issues as a journalist, I just wanted to set a very little amount of groundwork about the issues that we're talking about today and how these various legal challenges that are pitting government control over education with individual liberties, how these are making themselves felt and playing out around the country. Many of you have heard the term critical race theory to refer to a bundle of concerns about the introduction of topics involving race into the educational day. We all know that critical race theory has come to sort of cover a multitude of topics, and I will try to use air quotes when I refer to it, since it is not strictly limited to what academics think of when they think of critical race theory. But there are now, as we speak, with the recent addition of Florida and Georgia, 11 states that have statutes on the books that restrict teaching topics that are associated with or are regarded as being affiliated with with critical race theory. Bills have been actively considered in more than a dozen other states, and I've given you a couple of examples of the sort of language that is making its way either into statutes or some cases in state Board of Education rules and regulations. For instance, Oklahoma's, which Emerson will talk about in more detail shortly, has a provision saying that schools cannot teach in any way that causes an individual to feel discomfort, guilt, anguish, or distress on account of race or sex. And of course, these are bringing the ability of government agencies to dictate what is taught into collision with the rights of teachers, the rights of students, the rights of families. And just to show how complicated this issue is, there are actually civil rights cases being brought on the side of restricting the teaching of racial topics in places like Illinois, Nevada, Pennsylvania, Virginia, where people who are proponents of restricting the use of critical race theory in schools are bringing challenges, asserting that exposing children to these topics actually violates either their civil rights or the parents' civil rights, or in some cases the teacher's civil rights. So it's an enormously complicated issue with a lot of moving parts to it. We've also, in addition to the issues involving race and the teaching of race during the school day, had a wave of laws and policies and regulations also restricting the use of materials both in the classroom and in some cases the availability of these in school libraries that discuss issues of gender and sexuality. In recent weeks, the governors in Alabama and Florida have signed statutes that restrict the discussion of topics relating to gender in elementary grades, that's the K through 5 grades, you see sort of the operative language from the newly enacted Alabama statute, no classroom discussion regarding sexual orientation or gender in a way that's not age appropriate or developmentally appropriate. We'll talk a little bit later about what sorts of legal theories and challenges might emerge. The Florida statute is already in court just 3 days after Governor DeSantis signed House Bill 1557 into law. A broad-based lawsuit was filed in the Northern District of Florida, raising First Amendment, due process, and equal protection claims to challenge the enactment of that statute. There are also a wave of what might be called parental opt-out statutes, laws that don't necessarily ban the teaching of these topics, but do require disclosure when schools are intending to teach topics that touch on issues of sex and sexuality. And 4 states, Arizona, Arkansas, Montana, Tennessee, so far have enacted these parental opt-out statutes that say, well, a parent could choose to opt their child out from this curriculum after being told that it exists. In addition to classroom instruction, the school library has now become a battleground over freedom of speech and the freedom to read. PAN America, the anti-censorship organization, recently released a report, as did the American Library Association, looking at how broadly challenges are being mounted to the availability of books with LGBT topics in school libraries. Texas has been an especial hotbed of these challenges. And so while the classroom has been the primary focus of legislative and school board regulatory activity, the library too is being targeted. And these bring up potentially different routes of legal challenge, as we'll talk about later. And so with that, I'd really love for Talia to speak with us about, we asked her, as somebody that is covering issues of education in Texas, where so many of these issues are coming to the fore, about what it's like to go to these school board meetings and these state board of ed meetings where these very, very emotional and divisive issues are being thrashed out. So thanks for joining us.
Thanks so much for having me on. I'm really looking forward to this discussion. I have been a reporter at the Dallas Morning News on our education team for about 1.5 years, which coincides with the spike in all of these issues. So I don't really remember what slow news days looks like, but it's been very fascinating to watch this. These 3 letters, these 3 words, critical race theory, start off as something that made people squint during school board meetings and look on their phones and turn to Google, to something that is now just almost an accepted catch-all term in some circles for so much of the work that districts are doing. So I thought it might help to start with a statewide perspective, and then I was hoping to delve into 3 districts that I think exemplify different issues of what we're seeing here in Texas. Texas is home to more than 1,000 school districts. So each place you go, there's something, a new approach to these types of issues, but I do think these 3 places will give a good overview of what we're dealing with right now. So as you laid out in your introduction, Frank, Texas is one of the states that passed anti-critical race theory legislation. The laws don't explicitly use those 3 words, but lawmakers are very clear that's what they're going after. They have a whole range of language, some that's very prescriptive and specific, such as no requiring the teaching of the 1619 Project, no teaching anything that, slavery and racism or anything other than deviations of the founding principles of the United States. Of course, we know several founding fathers did own slaves, but that is some of the very prescriptive information in the law. But there's also some very vague language about, no training of any sort that requires or stereotypes on the basis of race and sex, no required discussion about currently controversial events. So what has happened in a lot of classrooms and for a lot of teachers is that they feel they don't know exactly what will chafe up against this new law. And so what a lot of education advocates and free speech experts that we talk to say they worry about is the chilling effect, that there will be, even if this isn't exactly spelled out in the law, there'll be something that causes a teacher to look inward and say, hey, I don't want to go there. Even as students, of course, are asking questions about what they're seeing on the news every day. there are certainly plenty of currently controversial issues that students have questions about. So a few months after this law was signed by Governor Greg Abbott, a lawmaker who was running for Attorney General at the time sent out a list of about 800 books to a bunch of superintendents. And he said he wanted them to comb through their libraries and say if these books were there. And these books were anything from The Confessions of Nat Turner, Between the World and Me. There were picture books about the Black Lives Matter movement. There were children's books about puberty, like what is it like to go to a gynecologist for the first time? There was a lot of books about, iconic people in the history of the LGBTQ movement. So those were all on this list, as well as kind of just another vague ask to look for books that might make students feel discomfort, guilt, anguish, or any form of psychological distress. And I think we're seeing that type of phrasing come up a lot. And it was all because of that student's race or sex. So the Dallas Morning News kind of did an analysis of this book, and the authors were almost entirely women, people of color, members of the LGBT community. So it was helpful to see like what kind of books were coming up. So those two things were kind of escalating these conversations across the state, all kind of feeding off of each other. And that was starting to change and, like I said, escalate the conversation in several districts. So the first one I wanted to take a look at was Keller Isd. I don't know if any of y'all have listened to the South Lake podcast, which did a great deep dive into what these fights look like in districts, but Keller kind of borders South Lake. They're similar communities. And they were the first district in the state to come under state investigation over the library books that they offer. The state said, hey, we want to know how you're finding these books because we feel some are inappropriate. And that kind of set off this wave of challenges from parents, from community members. They keep an ever-evolving list on their website of books that have come up. And that's Toni Morrison, that's Out of Darkness, one of those other books that the ALA and PEN America has pinpointed as a big challenge. There's All Boys Aren't Blue, there's the Bible. We can't tell if that one's a joke or not, but it's certainly on there. And those books were all challenged. And what happened is the district convened groups of parents and administrators to meet behind closed doors and decide the future of those books. And some of them were put back on the shelves, some were taken off, some were, you can only check them out with parental consent, which advocates say raises concerns about, the ability of kids to read the books they want to read in a space like a library. So this was all very secretive. Even the people on these committees reviewing the books had to sign confidentiality agreements, which really surprised us. And we were told that as part of the committee considerations, they had to take students' First Amendment rights into account. But again, we can't be in there. We can't be in the room where these discussions are happening. So it's really difficult to get a sense of what exactly is happening there. So we've been challenging the district to try and get more information, documents, all that fun stuff under the Freedom of Information Act. But they've been pushing back because they say there is all of this external pressure, including from the governor, who has said, if you give a child a book that we consider pornographic, which we know does not always adhere to the technical definition, you could be criminally charged. So there's a lot of that pressure, and that's why they're feeling like they need to stay behind closed doors. We talk to Freedom of Information experts who say, I don't know if that's an excuse. These decisions are far too important to be made by nameless, faceless people, but that's what we're dealing with in Keller. And we haven't seen the result of the state's investigation, but I'm sure that will be interesting to follow. So that's Keller. And then there's Granbury, which actually the ACLU has gotten involved with. So thankful for them for giving us some great information on what's happening. So in Granbury, they got that list from the state lawmaker of all those books, and they heard what Governor Abbott was saying, and they decided to remove more than 120 books from campus libraries shelves in a departure from their typical process of book challenging. They said that went along with the Republican state lawmakers' intentions, and so that's what they were going to do. The superintendent even made comments like, let's not misrepresent things. We're not taking Shakespeare or Hemingway off of the shelves. So that was a really big moment in that community. And when that happened, the ACLU weighed in saying like, this violates First Amendment rights. This does not go along with Supreme Court opinions in terms of reasoning for removing books if they don't align with the community's values, for example. And the ACLU also raised concern that we've heard from other librarians when we've talked with ALA members, that there's even like this shadow banning of books where librarians are, again, that chilling effect, removing books to kind of not deal with the ramifications. So in Granbury at this point, most of those books have been returned to the shelves, but there is a concern among advocates that once that book's been yanked, even if it's put back, there's a stigma attached to it. And what does that say to kids who see their identities in those books? So of those books, 8 were permanently removed. And the district actually held what they called a public inspection for people in the community to come and go through the books. Each one was marked with like multicolored sticky notes, which seemed to point the reader to what someone on that committee had found objectionable. And I met while I was there a high school junior who's non-binary, and they came because they wanted to see like, what does my school district think is unacceptable? And they wanted to kind of make a statement that they are still here in this district, and they aren't going away, they live there. And members of diverse communities live there too. So they flipped through one of the books, which was This Book is Gay. I don't know if you've seen it. It's on all those lists, rainbow cover. And when they were looking through it, they said, I don't think this is porn. I think this is sex ed. I think that this is telling the history of communities that I belong to. So we'll definitely be interested to see what Granbury does next, and we'll be calling the ACLU for updates. And then the last district that I wanted to go into is Grapevine Collieville Isd. And they have not, different from books, because I think, we have the library side and there's also the classroom curriculum side. And here, a couple weeks ago at one of those board meetings, like you've alluded to, that gets quite contentious these days, 2 trustees had proposed a new policy that they said was in response to community concerns about books, critical race theory, although they didn't really elaborate on who in the community helped them draft the policy they put forward. But it would pretty dramatically limit students' access to information about race and gender. And something new I saw was that it would label anything that had to do with human sexuality as potentially pornographic. And then the trustees would have to kind of vote on each one of those things. It also had rules about, encouraging or supporting gender fluidity and rules around pronoun usage. And they said, if employees violated this, they could be fired or their pay withheld. So it's not close to being passed. This was just a proposal. But I do think it's interesting, especially with school board elections around the corner. These are some of the things we could potentially be seeing more of proposed in districts, because there is such a momentum around candidates who are opposed to certain certain issues that we're discussing here. There's a lot of money flowing into those races. But I do think the legal side will be so interesting too. We couldn't get a copy of it, but the legal team in that district issued a 48-page opinion on this draft policy. So there's certainly something to see in there. And like I said, this is having ramifications potentially on curriculum and books. And in this district, it made national news. A principal was fired because he was accused of teaching critical race theory. So it's very clear to see, this is happening and having some real effects across North Texas. So hopefully that's a helpful overview, and look forward to answering any questions.
Very helpful, thank you. And I've dropped a few links to the Dallas Morning News coverage, which is very thorough of this issue, into the chat feature. Let's hear from Emerson Sykes, who is actually working on one of the earliest cases that may become a national test case involving Oklahoma on behalf of the ACLU.
Thanks so much, Frank, for the invitation to speak today, and thanks to all the participants and to the panelists. It's an honor to be with you. So, I think Frank set the stage, talking about how widespread this issue has become across states, how many states have introduced these kinds of policies, how many have been introduced. I've started referring to them as the new variants of these laws too that have started coming out. We talked a little bit. Talia was talking about the book bans. So my job, as Frank said, is a senior staff attorney at the ACLU's national headquarters. I'm based in New York, and I'm on the Speech, Privacy, and Technology Project. So I litigate First Amendment cases. I think it's important to say at the outset that, the issue of how we talk about our history and our culture in schools, especially in our public schools, is something that gets to the heart of who we are as a nation. It's something that is a debate and a conversation that has been going on since the founding. And it goes far beyond any particular law or lawsuit or policy, and really gets to the core of who we are as a country and how we talk about ourselves. So I just want to lay out that I'll focus on some of the legal arguments, and specifically the First Amendment legal arguments that we can bring to bear against these statewide laws. But that's a very narrow slice of this enormous issue. And so I just want to be explicit about sort of where I fit into this puzzle, but acknowledging the ACLU has organizers, we have legislative advocates, we have communications professionals who are message testing and doing all sorts of social media campaigns. There's a lot going on just within the ACLU national office. We also have affiliates in all 50 states who are active on these issues. And of course, there are many other organizations. I'm sure lots of you are a part of organizations that are active on these issues, whether it be the African American Policy Forum out of UCLA that's done a lot of organizing. We are working with a national coalition of legal organizations that are considering legal challenges in various states. The NAACP Legal Defense Fund, the Lawyers Committee for Civil Rights, many, many, many others, Lambda Legal, Southern Poverty Law Center, lots and lots of organizations are active on this. So I want to sort of give a picture of the broader landscape, and then I'll focus in on what the ACLU has been doing, because obviously that's what I know firsthand. But before I get to the specifics of the ACLU's work in terms of litigation, I think it's important where we start this story. Talia, you provided a lot of details of sort of what it looks like on the ground, what's happening on the school level, what's happening on the district level. And Frank, you provide some of the national context. And I think historically, what we've seen in the United States for generations from the founding was a whitewashed version of our history, right? That's what was taught in public schools for generations. And over the last couple of decades, we've seen significant progress in terms of presenting a more comprehensive and inclusive curriculum, making sure that students' identities are reflected in the narratives that are told in public schools, and encouraging a diversity of viewpoints and critical analysis of our history, the good, the bad, and the ugly. And I think what we saw, the ACLU works on a lot of different issues. I work on the right to protest. I work on campus speech issues. I work on the intersection of free speech and racial justice. So during the summer of 2020, I and many other colleagues were working for months nonstop just on the right to protest, specifically around racial justice protests after the murder of George Floyd. So it's no coincidence that our First Amendment team went from working full-time on racial justice protests in 2020 to working full-time on these bans on inclusive education in 2021 and 2022. I think we saw what many people refer to as a national reckoning around race. We were having the most open and widespread conversations about racial justice that we've had at least in a generation. An indirect response to that reckoning, we saw, I hate to even use his name, but a guy named Chris Rufo happened upon a honestly brilliant idea of sort of weaponizing the term critical race theory. And I've taken to this analogy where I say, he's using critical race theory as a bucket into which people can pour all of their racial anxieties. And I was very proud of myself for coming up with this turn of phrase. And then someone sent me a tweet of his where he basically said, I want to be able to pour everyone's racial anxieties into the bucket of critical race theory. And I was like, okay, this was not brilliant analysis on my part. This is him saying the quiet part loud. He's being very explicit about what his goals are and what his the trickery that he's trying to pull off rhetorically. But he, said, the real problem here is critical race theory, meaning the broader racial reckoning, steps towards a more diverse and inclusive education, all of the things that about sort of current contemporary social fabric that he doesn't like. And this was picked up directly by President Trump, apparently on one of his, Fox News watching binges. And he put out an executive order that listed several divisive concepts that could not be included in government trainings or for government contractors. The Ninth Circuit partially enjoined this executive order, and President Biden subsequently withdrew the executive order. So one would have hoped that this bad idea would have been gone for good, but it has lived to see many new days in the form of these state laws that Frank mentioned. More than 40 have been introduced at this point. 11 have passed. Many of them cut and paste directly the language from Trump's executive order. One of which is that phrase that you mentioned, the discomfort, guilt, or any form of mental anguish. That is directly lifted from Trump's executive order. That's in the Oklahoma law. It's also something Talia mentioned. And so, but, that's just the state level laws. We at the ACLU have chosen to focus on state level laws because we think litigating on a state level law will have the maximal impact. But so much of the action, as Talia was talking about, is actually on the local level. It's on the school district level, it's on the school level, it's on the library level. So I want to fully acknowledge that in focusing on state level laws, you really do miss a lot of the chilling effect, a lot of the actual impact on students' education. So this is sort of the background, right? So we had these decades of whitewashed history. We had some significant and successful efforts towards a racial reckoning, and now this is the backlash. And so how has the ACLU responded? So we've been in touch with our affiliates all over the country, trying to figure out when and if it might be prudent to use litigation as a tool to try to push back against these things. And we've focused on Oklahoma as Frank called it a test case. I think, yes, it was the first federal lawsuit challenging one of these inclusive education bans on constitutional grounds. There was a previous lawsuit that was successful in Arizona that struck down one of these laws, but it was on procedural grounds. They had grouped it with a mask mandate and a redistricting, I think, as well, and maybe vote by mail. They had put a whole bunch of stuff together, and that was against their single issue rule in Arizona. So we put that in a slightly different category, but I don't want to, when I say we were the first, I don't want to discount the importance of that Arizona lawsuit. But we were the first ones to bring constitutional substantive arguments against one of these laws. Subsequently, there's been we also filed in New Hampshire along with several co-counsel. And there's also been, as Frank mentioned, a lawsuit in Florida around the Don't Say Gay law. And so, there's also been an initial filing against Florida's Stop Woke Act. But I'll focus on our lawsuit now in Oklahoma. We filed along with the Lawyers Committee for Civil Rights Under the Law, the ACLU of Oklahoma, and pro bono counsel at Schulte, Roth, and Zabel. And we decided to focus on Oklahoma because of a few factors. One, the law covers both K-12 and higher education. And as many of you will know, the First Amendment is particularly protective of free speech rights and academic freedom rights in higher education. So we thought that we would have some strong First Amendment arguments against the laws that cover higher education. The laws vary, right? Some of them just cover K-12. Some of them cover K-12 and higher ed. Some of them also cover government employees. Some of them also cover private employers, which we think is particularly problematic or uniquely problematic. But the Oklahoma law, we thought, because it covers K-12 and higher education was a good test case because it directly quotes so much of Trump's executive order, and it's using that template that has been used in so many other states that are ruling against this law, we think can easily be applied to other laws. We think the 10th Circuit has significant good jurisprudence on First Amendment and academic freedom. It's complicated, obviously, but in general, there's some pretty strong protections. And we also thought that the story that we could tell about, on the centennial of the Tulsa race massacres, that the Oklahoma legislature saw fit to really poorly draft a law aimed at prohibiting the discussion of racism and sexism, which we think is supremely misguided. So we filed suit on behalf of 7 different defendants. Our lead defendant is the Black Emergency Response Team at Oklahoma University, and I'll come back and talk about why they're our lead plaintiff. We also have the American Association of University Professors at the University of Oklahoma, so that we have both higher education teachers and students. We have the NAACP of Oklahoma on behalf of its members who are teachers and students in Oklahoma public schools. The American Indian Movement of Indian Territory on behalf of its members who are teachers and students in public schools. 2 individual teachers and an individual student. And one of those individual teachers is from Edmond Public School, and he received guidance from his district that said, in order to implement this law, well, first they said that certain provisions of the law, quote, no one really knows what this means. So there's one provision of the law, one of the divisive concepts that's literally incomprehensible. It has a triple negative in it. I can't even remember how it goes because it doesn't make sense. Basically, it says you cannot teach that anyone cannot or should not attempt to treat anyone without respect to race or gender. So if you know what that means, let me know. But basically, that is an example of one of the sort of more absurd provisions of these laws that, literally the school district said we don't know. But to enforce the other parts, this school district, Edmond Public School, said just avoid the use of the terms diversity or white privilege, just to be safe. And so we think this is exactly how this law was intended to be enforced. Broadly, and its vague language opens up the door to broad and discriminatory enforcement that ultimately impacts children's education. We sued the governor, the Board of Education, the Board of Regents of the university system, Edmond Public School, and so there was sort of the state defendants, the University of Oklahoma defendants, and the school district defendants. So we decided to build our case in that way because we really wanted to be able to tell the real story of how broad the impact of this law might be. And so just one more minute, Frank, to just talk about some of the specific problems that we saw with the law and the claims that we brought. So as I mentioned, for K-12, there was the list of divisive concepts, some of which are seemingly innocuous, like basically don't teach that one race is inherently superior to another, of course. Others are incomprehensible, like the one I mentioned. Others are really overbroad and problematic, like the one you mentioned about discomfort, guilt, or any form of mental anguish, right? Like one is that the pretext of that provision is that they're protecting white students from feeling bad about talking about racism. While the opposite is true, that I can tell you as an African American sitting through whitewashed history, I felt supreme amounts of discomfort not seeing myself reflected in the curriculum. But I think there's also the point that some amount of discomfort is also a natural part of the learning process. I mean, no one's saying that we should intentionally make children feel guilty or make them feel bad or any of the sort of really terrible examples that you might read in the press every once in a while. But I do think it's really misguided for a state legislature to say that you can't make anyone feel uncomfortable in class. And that just covers far too much. And in the inevitable outcome, as Talia mentioned, is going to be this chilling effect, whereby teachers will be damned if they do and damned if they don't, right? If you teach an inclusive history, you might be accused of violating one of these divisive concepts. And if you don't teach an inclusive history, then you know that you're negatively impacting your kids' education. So you're really between a rock and a hard place. So very, very quickly, the 4 claims that we brought against the law are one, a vagueness claim on behalf of K-12 teachers. basically saying that, aside from the content of the law, if teachers cannot be reasonably expected to understand what is prohibited and what is permitted under the law, then they can't have their licenses at stake for violating that law. That's a due process violation. That's a vagueness problem. We have two First Amendment claims. One is about First Amendment protections in higher education. We think that it's a overbroad and viewpoint discriminatory infringement on academic freedom in higher education. And I mentioned that our lead plaintiff is the Black Emergency Response Team. They were formed in response to a racist incident that happened on campus. These happen on every campus, a Halloween party, whatever it is. So in response to this racist incident on campus, the Black Emergency Response Team created a list of demands. And they protested, they had sit-ins, they had meetings with administration, they did press conferences, they did all the things that activists do. And one of their demands was to create a diversity course for all incoming students to try to provide some norms for how they wanted to live in a heterogeneous community. And this demand was actually met by the university, much to the consternation of FIRE and several other groups who were sort of outraged that they would have such a required course. But what we then saw was that the state legislature, they cut and pasted the divisive concepts from Trump's executive order and applied them to K-12. But they also tailored a specific provision to what was happening locally. And we see this in so many laws where they use the template, but then they adjust it to get at whatever is the news of the day in that particular state. And what the Oklahoma legislature did was they prohibited, quote, any orientation or requirement that presents any form of racial or gender stereotyping or bias, right? So you're not allowed to have any orientation or requirement that presents any form of racial or sexual or race or gender stereotyping or bias. So clearly what they were trying to do was target that specific orientation course that was approved, right? But the way they wrote it, they also cover any requirement, which could be a required course, it could be a required reading, that merely presents racial stereotyping or bias. Not that advocates it, not that requires students to advocate it, not that, indoctrinates students in the positive aspects of stereotyping and bias, but merely covering these topics in any requirement on a college campus is a violation of the law. And so we think that that is patently unconstitutional under the First Amendment. We also have a right to receive information claim on behalf of K-12 students and teachers. Now, the First Amendment, of course, protects the right to speak and to assemble, but it also protects the right to access information. And the Ninth Circuit, especially in other courts, have recognized that this applies specifically to students in public school. And there's a relatively permissive test. It says that for the school districts, they're going to have to make their curricula, right? They're going to have to make decisions about what to include and what not to include. They have a lot of discretion to do that, except that it must be at least reasonably related to a legitimate pedagogical interest. Just basically rational basis review, which usually isn't so hard to meet. But here, what we've seen are these poorly drafted, overly broad restrictions that are purely politically based and partisan talking points without any basis in a legitimate pedagogical interest, and in fact run counter to the consensus in the educational research that says that an inclusive education improves students' understanding, it improves their behavior, and it improves their academic performance. And even these state standards themselves, produced by their education officials, say that the curriculum should reflect students' variety of identities and present critical analysis for dealing with different viewpoints. So this effort by the Oklahoma legislature and by other legislatures directly undercut the legitimate pedagogical interests that are being asserted by other parts of the state. So even though courts are quite deferential to state officials to formulate their curricula, we think that in the case of Oklahoma and HB 1775, they failed even that low bar. And the last claim we have is an equal protection claim based on the racial animus that legislators displayed in the passage of the law and the racially disparate impact. Of course, inclusive education is good for everybody, but the lack of inclusive education is particularly harmful to students of color. So I know I've gone far beyond my 12 minutes. I apologize for rambling, but that's, I hope, a bit of an overview of sort of how we are approaching this issue on a national level, and then a little bit of a deeper dive into the Oklahoma case.
Very helpful. Thank you. And there are such a bundle of legal issues tied up in that one case. Hopefully we'll get a chance to unpack a little bit the distinction between constitutional rights at the higher ed and the K-12 level, because those can play out differently in the courts. I want to pass the mic to Tom Hutton. I asked him, Emerson was asked primarily to address that bundle of issues surrounding, air quotes, critical race theory bills. And I asked Tom to please take the lead on addressing that bundle of issues. The other hot button social topic that is playing out in schools and school boards around the country is the pressure to remove LGBT themed books from both the classroom and the library. And there is some, although not optimally helpful, guidance from the US Supreme Court on this. And no better person to explain it than Tom, who for his career has specialized in advising school clients. So please take it away, Tom.
Yeah, thank you very much, Frank, and everyone. As Frank mentioned, in a past life, I was a school board attorney, including in-house at the National School Boards Association. And now I'm with the Education Law Association, which is kind of an umbrella organization just for everybody interested in education law. That includes the professors who teach the courses, the administrators who intersect with the law enough that they want to keep on top of it, the attorneys who practice in this area from representing all kinds of parties in both higher ed and K-12. So we kind of hear from around the country, from all people wearing all kinds of different hats, how these things are playing out. And I do actually have some slides to share to kind of help keep myself organized. And I did include not just the library side, but to start off with the broader curricular side, some of which you've heard how it's playing out from Talia and some of the legal concepts that are at issue from Emerson. But I'll just mention some of the key cases because there's only a few and they relate to one another. And just, big picture in this area of either curriculum or libraries. And Emerson alluded to this. I mean, states can impose requirements on local authorities and parents. They have a lot of discretion in this area. It's primarily a state responsibility. Within those requirements, local school authorities also have very broad discretion in this area. But parents do have prerogatives as to the raising of their children, and those things have to be balanced sometimes by the courts. And the courts, when they do decide to sort of step in and mediate these issues, they tend to exercise a good deal of judicial deference and judicial restraint. They don't want to get into second guessing all these educational decisions and having to be, the sort of school boards. And so you see that tension between, there are constitutional rights from all parties that they have to help mediate but some judicial caution about how they go about that. And really the first Supreme Court foray into the curricular area was a 1923 case in which there had been a 1919 statute that prohibited the teaching of language other than English, in a language other than English, and the teaching of a foreign language to any student who had not yet completed 8th grade. And that applied also not only to the public sector, but to the private. Emerson mentioned that there's some statutes today that are reaching beyond public entities and reaching beyond educational entities. So in this case, there was a private school teacher who was convicted of teaching German to a younger student. And in many parts of the country at that time, German was the primary language other than English among that sort of immigration wave. And this student and this teacher was convicted. There were actually criminal aspects to this. So the court found that in this case, the statute infringed on the 14th Amendment liberty interest of several different entities. The teacher in sort of their educational calling, and we'll talk about that a little bit later. Students in the opportunity to learn, and that aligns with one of the claims that Emerson mentioned that they're bringing, the ability to receive information, and parents in controlling the education of their own children. And that latter category can sort of play out in any direction of these political disputes, depending on where the parents are asserting it. The context here politically, this is very important, there's a larger political context playing out and making schools the sort of locus of culture wars. And at that time, this statute was passed amidst all the anti-German anxieties of World War I, where we started calling anything German liberty this or liberty that, and that kind of a thing. And there was a lot of anti-German sentiment. And so it was interesting when the court addressed it, the court said, maybe in wartime when we're fighting the Germans, we would be having a different discussion. But now in peacetime, a few years later, the argument why we need this is maybe weaker, and they found that it did infringe on these rights. Oliver Wendell Holmes actually had a dissent in the case where he found the statute wasn't arbitrary. And after all, it only applies to children. And a lot of these children may not ever hear English at home because it's the other language is the only one. And he used the word reasonable men because that's how people wrote at the time. Reasonable men can differ. So there isn't a constitutional kind of issue here from his standpoint. And there again, there's sort of that theme of, do we really as a court want to get into this stuff? And that early articulated by Oliver Wendell Holmes. So we've also had, the Emerson case from Arkansas, and that was a statute prohibiting the teaching of evolution. So a little like the famous Inherit the Wind monkey trial of 1927, but a lot later. And here the US Constitution was invoked by the Supreme Court because of the Establishment Clause. So they said basically the motives behind these curricular decisions are to favor one religious viewpoint, and that's an Establishment Clause problem. There's a lot of robust discussion today about how strong the Establishment Clause is anymore, but there have been a theme of court decisions in curricular areas that deal with Establishment Clause issues. And the same result happened in 1987 in Louisiana, where the law had to do with kind of equal time for alternative sort of religious-based theories of that are held up as counters to evolution. In the library area, the seminal case, and this was the one that Frank, I think, was alluding to, the school board was sued over removing books that some school board members had gone to a national conference of conservative folks, and it was a little like the list that Talia was referring to. These lists are being handed about nationally to people to take home and start scouring library shelves, and the school board members came home and started getting these books removed, and they were sued by parents who were concerned about the removal. And the reason Frank mentioned this kind of messy is it was a whole lot of opinions out of one case. There was a plurality decision with 3 justices, which basically there was joined in concurrence, at least as to the outcome, by 2, so that got them to 5, but it was a plurality opinion. And it said the right to receive, this again gets to that right to receive information that Emerson said is one of the claims that they're bringing. And a concurrence separately said, well, you can't remove books for because you disagree with the ideas. And by the way, the plurality also said that they're not considering whether things can be put on the library shelves. They're very specifically, it's a negative, can they be removed? The other concurrence said, this is Justice White. He said, there's a fact question to me, because if what was going on here was vulgarity, we're done with this discussion. We're not going to get into second guessing local people about whether they think something is vulgar. And if if you're familiar with obscenity law, there's a strand of thought about local mores guide that decision. So he would have remanded and gotten more guidance on that, but he was okay with the outcome. So he joined in that. There were 4 separate dissents. And in one way or another, the concern had to do with this deference to local discretion that Emerson mentioned. And, for example, Justice Powell was a former school board member and a former state school board member, and he was a little bit more deferential. Justice O'Connor, was one of the few formerly elected officials we've had in recent memory and who to serve on the court. And she also was a little bit expressed some hesitation about getting into second guessing education officials on things like this. So basically the takeaway, courts do still recognize some broad authority, especially over things that have to do with vulgarity and age appropriateness. And that latter one gets messy, because what's age appropriate, I think has changed. Because of how our society has changed, and things that might have been considered too controversial at one point are just sort of part of our life now, and how educators navigate that is hard. Then generally speaking, there's a higher bar for library decisions versus classroom discussion, classroom instruction. So a little bit more protection, not unlike what Emerson referred to. There is a little bit more, First Amendment protection in the higher ed context and the K-12 context, but also within the K-12 context, there's libraries. It's a little bit of a stricter standard. And I will say that, this case and others illustrate the kinds of things that we've heard about from others. There's a national sort of culture warrior agenda that then tries to rope in local officials or to be warriors in those cultural wars, or finds those local decision makers caught in the crossfire. I will just note that we included in the resources a recent article that ELA published that questioned whether PICO, the extent to which PICO still applies in schools, and they particularly looked at kind of a middle area. I mentioned libraries versus classroom, but classroom libraries are a little bit in between. So where do they end up in terms of how high the protections are? And it's an interesting article and provides a really good breakdown of the plethora of opinions that came out of PICO. So there's just some variations, and I won't go into the various cases, but I'll mention that these have all been litigated at one point or another. This is not an area that has yielded vast amounts of case law because, again, courts they wade into this area cautiously. But there's been litigation over requiring intelligent design theory to be taught in science classes. Disputes over whether a parental opt-out is required. This is a big thing in a lot of the issues and how local officials try to sort of get out of being caught in the crossfire is parental opt-outs. But sometimes there are questions raised about, well, if my kid has to opt out, is that sort of stigmatizing them? And we'd rather just have this instruction not occur in the school than have my kid have to opt out. So those things get discussed. There was a provision in federal law in the largest federal statute that gets renewed in a new iteration every few years that banned the use of federal funds for, quote, material that encourages sexual activity or, quote, is legally obscene. And they would just say, going back to what Emerson was saying, when you actually look at what's being, some of it is pretty innocuous, like how many schools are out there from, and I think Talia alluded to this too in some of the Texas language, like nobody's out there encouraging sexual activity or publishing or sharing legally obscene things that fit the definition with kids. And so reading closely at these statutes, what really is being prohibited? And is it really happening anywhere? This goes to the sort of checking your phone critical what? So, that I think I'll talk to a little bit later, but there's a question about, is some of this just sort of political red meat? And some people might quietly say, wink, wink, nudge, nudge, there's no impact. Don't worry, because look at what we've actually said is prohibited and nobody's doing it anyway. But that's problematic for a reason that's been raised, and I'll mention. The removal of the Bible has been brought up. If you read the Old Testament and you're looking to get sex and violence and all sorts of things off your bookshelves, it's pretty hard to think about how that doesn't fit that, but I think some of those have been brought tongue-in-cheek. Removal of books depicting romance between teenage girls, removal of books depicting same-sex partners. And this is where I said, our society has changed a lot. So there may have been a time not so long ago where parents, even relatively open-minded parents, might have been squeamish about at what point we start having these conversations in elementary schools. But what do you do when our nation protects same-sex marriage now and kids in the class come from families like that? And if you omit that family model from your discussions or your examples or anything, that is sort of like the equivalent of what Emerson talked about, getting whitewashed history. And you don't get to decide, well, this view is sort of the innocuous, uncontroversial version, and this equally problematic version is not controversial. Removal of books for factual inaccuracy. So there was a highly publicized case in Florida that had a book that dealt with Cuba that was felt to sort of extol the virtues of Cuban society under Castro, and that was removed. The lower court struck down that removal, and then on appeal they said, well, factual inaccuracy is, again, that's a different category than just we dislike the viewpoint. And this is an interesting one. There was a case involving internet filters. So there's some federal law that says, that requires school districts to protect students from certain kinds of online content. And the imprecise nature of the AI used to do that stuff kind of had the effect of saying, well, anything that addresses same-sex relationships positively is sex. And that's where you see this sort of blurring of anything dealing with same-sex relationships sort of somehow bleeds into pornography and that kind of framing of things, whereas negative views of that were viewed as religious, and so they're permitted, and that was struck down. So just a quick word on teachers. there was that language in that Nebraska case from 1923 that referred to the right of teachers to pursue their calling. But generally speaking, academic freedom is seen more of a doctrine in higher education law than in K-12 law. And that's understandable when you go back to, again, we started out talking about the wide discretion that state and local officials have to set curriculum. We have established academic curricular standards that are the ones that are tested in standardized tests in schools and are evaluated on. So there is a little bit less discretion on that. And in general, when teachers bring kind of assert their First Amendment right when it comes to instruction, you tend to be under the auspices of a decision from the Supreme Court, Garcetti versus Cebios in 2006. It said, when you're wearing your employee hat as a public employee, we're not talking about a First Amendment situation. You're not like a citizen asserting your right to express yourself outside of your employment context. You're being paid for your speech, and that's a different kind of context than would be the case otherwise. That would apply, I think, differently in higher ed, where academic freedom is so ingrained into our legal doctrine. And I just mentioned that because, again, one thing was brought up was being even-handed in terms of, well, if you frame the conservative scenario, now frame the liberal scenario, and teachers of all political stripes can kind of go rogue. And I will say, just as a non-legal analysis, but just as a political analysis, sometimes where these issues come to flare up, it is sort of a teacher who is a little bit inartful about how they try to present a comprehensive and all-inclusive approach. And if that kind of comes across, if you're familiar with the historical, kind of a Howard Zinn, like what we call gory history instead of glory history, and an uninterrupted litany of things that are wrong with America, that can kind of strike people who might otherwise be sympathetic to needing to share all the viewpoints and tell the full story as problematic. And not every teacher is equipped with the political lenses to deal with something that may kind of erupt on them and they didn't realize it. So I just mentioned, that's where the local discretion sometimes comes in. And then just without going into these in great detail, some of the details about the way these statutes are put together, this goes to the question of, well, is this really innocuous, or is this really intended to be vague to just chill people and scare people from even wanting to talk about race or gender at all? And you have to get into then not just sort of the what's being targeted, but how does the procedure that's being set up for the enforcement of this work? Is there a private right of action? Against who? Is it also against the teachers? Or as Emerson said, can they lose their certification? Who bears the cost if there has to be a magistrate or an arbitrator brought in to resolve a complaint from a parent? Is that on the school district? In some statutes, yes, that's the case. Are there damages available if you prevail? You get your attorney's fees, which oftentimes in litigation, that tail wags the litigation dog. And is there fee shifting if the school district or the charter school board that's being sued, prevails? Mostly not. It's, the risk is sort of all on one side, and that goes. So these details go to whether there's a harassment value of these statutes apart from what the actual specific language is that's being targeted. And that harassment value then goes to where this is just innocuous. We're just scoring some political points, to whether the chilling effect of just wanting to avoid any controversy and distraction whatsoever is just going to make us shut down lines of discourse and inquiry and learning for kids. And so I probably have gone over my 12 minutes too, for which I apologize, but that's kind of just the big picture landscape, I would guess.
Oh, hugely helpful. Thank you, Tom. And I see that several of you have maybe claimed one of the questions that was in the chat. So before I ask something, because I don't want to run the clock out and leave people in our audience with unanswered questions, was there anyone who wanted to answer any of those questions live? I might put you on the spot a little bit, Emerson, that a couple of the questions kind of clustered around really more of the policy question than the legal question, which is the how did we get here question, right? Several people were asking, well, how did critical race theory become this sort of a bugaboo, and as you've said, this vehicle into which people pour their racial anxieties?
Sure. Yeah, it's an important point. And there was a specific question around, well, is CRT even taught in schools? And I think going back to Rufo's Twitter admissions, he said, look, I want people, every time they see something they don't like, to think critical race theory. And I think to a large extent, he has been quite successful. And it's sort of, it has touched a nerve in such a way that when people hear it, they have an immediate reaction. And so I think, why is this important? I think because the term has been so co-opted. There's this sort of talking point that many folks have used that said, well, critical race theory isn't even taught in K-12. I think it's a little bit of a yes and no. Critical race theory, as properly defined, is a concept within the legal academy. It's a framework for understanding how race impacts institutions, including in unconscious and unintentional ways, right? So in that way, it's a framework for analyzing, especially legal institutions. And that is a high-level legal analysis course, second or third year of law school. But at the same time, the central insights from the critical race theory approach very much have trickled down and have played out in the ways in which we've reconceptualized how we present curricula at all ages. So it's not quite true either to say that none of the ideas that are meant when we use the term critical race theory have anything to do with K-12 at all. So I think it's a little bit of a problematic talking point, but it does get to this question of like, what are we actually talking about when we say CRT? I think, just quickly to highlight another issue that was brought up by a couple of the panelists is this intersectionality, to use another sort of Kim Crenshaw phrase other than CRT. And so I mentioned that we've been working on our First Amendment team hand in hand with our racial justice project, but we've also been working closely with our LGBTQ and HIV team and our women's rights team, because there is a lot of overlap. And, I talked about this Tulsa race massacre in Oklahoma and the targeting of the Black Emergency Response Team. And we think this law is significantly, if not primarily, about race and racial justice. But it talks about race and gender throughout. And it includes a prohibition on any trainings in higher education that have to do with, quote, gender or sexual diversity. So the targeting of LGBTQ lifestyles and issues is very intentionally and very explicitly in almost all of these laws. So I don't mean to gloss over that. And I think it's an important note that those things are there. I think, relatedly, these book bans that Talia was talking about and that we've seen in many places, those have been happening also over the last decade. Our LGBTQ team has been litigating bans on LGBTQ books for several years. This predates the Trump executive order. This predates the summer of 2020. This has been a consistent thing, and we're building off of the successful arguments that they made in those cases now that it's being applied not only to LGBTQ, but also to Uncle Tom's Cabin and other books that deal with race. So I want to make that explicit link to the work that our LGBTQ colleagues have done. And then by analogy, I think, Tom, you were talking about sort of opt-out when we talk about sexually explicit material, which is often misused in the context of LGBTQ, but even for like actual sex ed, there has long been an opt-out option. And I think what we've seen is this idea, and Chris Ruffo, again, sorry, I keep talking about this guy. I don't mean to give him more airtime than he already has. But he recently tweeted also that, we know that these bans are probably unconstitutional. So we're going to pivot to talking about transparency and parents' rights and access to information. And we're going to own the libs by making them look like they're against transparency. And to be fully transparent, we at the ACLU, of course, we've been for transparency for generations, for 100 years. But we got ratioed in our first tweet on this topic because people said, what are you, against transparency? So, score a half a point for Chris Ruffo. But the point is that under the guise of increasing transparency, increasing parents' access, we've tipped from parental empowerment to opt out and direct their own child's education to granting individual parents veto power over curricula and entire, curricular initiatives, curricular approaches, not just a particular book or a particular topic where they can say, oh, I want my kid to go to the library or sit out for that particular lesson. Now they're saying, no, you can't teach this to anyone because this makes me, quote, uncomfortable. So I think that that's an important distinction to make between and how those arguments around parental access and opt-outs are being used versus how they are in real life. And then one final note on the don't say gay, because I think this is something that is closely related, but interesting to point out. You talked about it a little bit in your opening slide, Frank, about how both Florida and Alabama have passed quote unquote don't say gay provisions. But I think I often get the question, which is sort of, all you do is complain about everything ACLU. You see a problem when there isn't a problem. Is there any way to get at this, quote, some people feel legitimate problem with some of these, as you said, Tom, these inartful, teachers who have gone overboard or have misguided approaches? So is there any way to rein in those folks without running afoul of, or without getting the ACLU to sue you? And so I think almost all of these laws have some problem with them. They're misguided to begin with. Some of them don't essentially do much of anything, but just highlighting the difference between the Florida law and the Alabama law, I think it provides some insight to sort of how we analyze these things. So in Florida, the law says you're not allowed to talk about sexual orientation or gender identity at all between kindergarten and third grade, and only as age appropriate thereafter. And this gets at a couple of the points that Tom was making, right? So the special provisions for very young children, and about age appropriateness. And so what I think is the main First Amendment problem with the Florida Don't Say Gay law is that core categorical prohibition from K to 3, right? That is to say, you are not allowed to talk about anything related to sexual orientation or gender identity in K to 3. There's no such thing as age appropriate for those kids, which is patently ridiculous because everyone has a gender identity. And those kids might not have identified their sexual orientation yet, but they certainly have a gender identity. And so by the letter of the law, they're not allowed to talk about themselves, their families, their parents, their siblings. Any reference to gender identity is prohibited for kindergarten to third grade. I have a 5-year-old and a 7-year-old. At that age, they learn based on what is around them. It's very experiential. They have to engage based on terms that they understand and using their family. So the idea that you cannot talk about your family structure in a kindergarten class is just absurd. And so we think that that's the main problem with the First Amendment violation in the Florida Don't Say Gay law. By contrast, the Alabama law says in K to 5, you can only talk about sexual orientation and gender identity as age appropriate, right? So there's actually no categorical ban. It just says everything has to be age appropriate. As Tom said, age appropriate is often misused and likely will be misused in Florida. But I, for one, would have a hard time getting in front of a federal judge to say that facially requiring age appropriate teaching is unconstitutional. I think that you can't really, you got to wait for that to be misapplied in order to challenge it because, age appropriateness is not a standard that a judge is going to say is unfair, even if it might be misused.
So Emerson, you perfectly anticipated and set up, and whoever would like to take the lead on this, there's a question from Arlena Barnes in the chat that we are seeing, and you mentioned the term variant, Emerson, that maybe a new variant of this legislation is more about transparency of curriculum / parental opt-out as opposed to a categorical ban. Is that both as a matter of public policy and a legal matter more acceptable, or is that vulnerable to challenge on either ground? Tom, I wonder if you have thoughts on that.
I think similar to what Emerson said, it's harder to go in front of a judge and say, hey, this transparency is a problem. I think as a policy matter, if you are a school just trying to do your job and you're worried about, just the administrative burden of all these things, and they've proliferated in federal law as well as state law about disclosures of, and if you're a parent and you get all these notices all the time, you know what I'm talking about, right? But the more we pile on, you have to send formal notices to parents all the time about everything, and there's an administrative burden there. And look, schools want to engage parents, but there is a point where I guess one issue is how much and how many different things you have to be on top of, and then another is what are the gotchas if you drop the ball on something? Oh, the notice went out late. What are there remedies? Are you hauled into court, or is it, what happens? And so I guess some of the finer, the general concept of disclosing things to parents is a much preferable way deal with these things and discussing bans or that kind of thing. And yet even those can have practical implications for public schools and both district and charter schools who are navigating these political issues and these constitutional issues where it just becomes one more death by 1,000 cuts in terms of compliance things.
I'm actually very glad that you used the phrase public schools or charter schools, because that's something that I should have said at the very outset of this, right? When we talk about constitutional rights in schools, we're always talking about public institutions, because that's where the courts have told us that constitutional rights apply. And so as a threshold matter, anything that we've talked about, whether it's due process or First Amendment rights, we're talking about the context of public education, but which includes charter schools, because charter schools are legally regarded as public schools subject to constitutional limitations. There's a good question in the chat, but before I get to that, I want to bring Talia back into the conversation. And I'm going to drop a link in the chat to this, because this has actually just been going on this week where I'm from in North Florida, but certainly replicating itself all over. There was a school board meeting here in the Jacksonville area where 290 people showed up to testify at a meeting that went until 1:30 in the morning on a non-binding resolution expressing the sentiment of the district as to the newly enacted state statutes. And even that brought almost 300 people out to testify, resulted in the board actually having to adjourn the meeting because there were so many speakers, more speakers than they could accommodate. And so I want to tell you, could you talk a little bit about, I guess, two things. First of all, just sort of what that atmosphere and that environment is as you're seeing and maybe talking to other education writers. And also maybe a little bit too about, I know that journalists, and let's go ahead and say women journalists especially, are on the receiving end of a lot of hostility when they find themselves touching any kind of a hot button social issue. So maybe you can talk a little bit about that as well.
Yeah, I haven't been to a board meeting quite with 300 people, but they are certainly packed. I mean, there are protests before and leading through the public comment section. A lot of the times you'll see the same people at different districts, it's the same people, different districts that will go around and spread the similar messages that they want to do. Actually, the last board meeting I was at, I sat next to an off-duty police officer who had been brought in for that meeting, saying, yeah, this happens a lot more now. So I do think that there is a sense that in a lot of ways, people are feeling like these meetings could explode at any time, which is, a far cry from some of the meetings I would be at, still till 1 a.m, but on, wonky issues like the budget and other issues. I mean, with so much learning loss and the ramifications of that, it does feel like there is a lot of time and a lot of oxygen at the local level going to these issues. And I do feel like, people feel in danger of harassment. I've been talking with, different people considering running for board, and they look at, what happens to trustees. I mean, I remember last cycle, there were flyers that went out comparing two candidates that were running in a really wealthy, mostly white enclave in Dallas. And they had, a green check mark under one candidate next to the words like conservative Christian mother, and a big red X next to another candidate whose photo had been darkened. And it said, has Black Lives Matter sign in yard. So I think that this is really everywhere. But I do think it's, not just a certain ideological side that's being driven to run. I went to one meeting where it was a mostly white audience that was there to listen to a sitting school board member talk about critical race theory and how to find it and how to fight back against it. But there was a Black couple in the back. And at one point they had the woman in the couple had to push back, and she said, who is the they you're talking about that's trying to spread critical race theory? And someone ahead of her in the audience turned and said, like, we didn't come to listen to you, so shut the F up. And that confrontation really sparked something in this couple of wanting to run, wanting to get involved. So I think it's not just parents on one side or the other that are involved in this and are facing really heightened scrutiny and all that. So that's some of what I've been seeing on the local level.
Could I ask you to say a word or two about something that we haven't actually talked very much about, that you don't see a lot of in this debate, and that is kids? Have you had a chance to talk to kids about this at all? Have you had a chance to talk to the actual people who are the consumers of this information and to discern where they're coming from?
Yeah, absolutely. So that student I talked about in Granbury, who they came to the public inspection for books, I think they are, and their classmates are really consuming all of this, really, really paying attention, far more than I did to what the school board was doing when I was in high school, just down the road. And I think that there's something really sparking in a lot of teenagers to fight back. So that student, for example, used their school's logo to design T-shirts. One of the things the superintendent said about the people supporting books was that they were radical gaslighters. And so this student designed a shirt with a G, like the logo of Granbury Schools, with in front of gaslighters, and they're selling these shirts and donating the money to the Freedom to Read Association. I think I have that organization right. So I think that students are very much paying attention and very much trying to do what is in their power to get the access to the information they want and they need. So if you recall, I said that student was looking through that book, This Book is Gay. They have a copy of it at home, and they're now lending that out to other students in their district who can't access it now through the library. So I think that students are really taking a lot of action and paying very close attention.
So great questions are pouring in on the chat. I'm going to take one out of order here just because it refers back to something that Emerson was just talking about, which is the distinction between the Florida quote unquote don't say gay versus Alabama don't say gay statute. Would you regard the Florida law as being more vulnerable to challenge?
I would, and it already has been challenged, and I think, and I wish those attorneys the best with their lawsuit. I think that they have a very strong case for trying to get that struck down. And I don't mean, and I think, I wanted to draw the textual distinction just to get into sort of ways in which these laws can be more or less unconstitutional or more obviously unconstitutional. But that's not to say there might not be other problems with the Alabama law. There could be all sorts of equal protection issues with how the law was passed or the intent behind the law. There could be other enforcement mechanism issues. So I don't mean to say the Alabama ban don't say gay law has the stamp of approval from the ACLU, far from it. But I just do mean that the way that these different provisions are crafted do impact our litigation choices about which ones are more susceptible to defeat versus others.
So very big picture question here that I will try to summarize. Teachers have a tough enough job without worrying about being sued. Do we see this movement as being more of an attack on public education generally, the kind of thing that might deter people from, frankly, wanting to go into the teaching field?
Well, if I can maybe I can answer quickly before turning it over to other panelists. I mean, I think I think it's exactly right. You talked about bringing students first, and so often this is a teachers versus parents issue. And I think we, in our messaging, very much try to bring students back to the front. Our lead plaintiffs are students. And I think it's really about their access to education and the quality of their education that really has to be at the forefront of our minds. I think it's also related to the question that you had about transparency, right? And Tom was talking about the onerous nature of the requirements. There's also, if you combine the transparency with the bans, which are often vague, with then a private right of action, which I think you also mentioned, Frank. So we have sort of an SB 8 style private enforcement through like onerous transparency requirements and a vague privacy ban. So even if the transparency component on itself might not be independently problematic, in concert with all of these other measures, what you have is a setup for a witch hunt against teachers. And we think that is not only a due process violation, but also has grave free speech concerns, even if it's not a tailor-made First Amendment argument.
And I'll just chime in, whether it's an attack on public education per se, and there are, there are political operatives out there who are like, the more kids that are attending private schools, that's better for our political future because public schools do all these things that we don't like. But I think it seems to me that the more likely kind of political explanation is, this theme of standing up for parents is a very effective political theme to be sounding in an election year. And if you saw what happened in the governor's race in Virginia, it had a big impact there. And borrowing Emerson's raising the term of intersectionality, there's a larger context here. If you want to think of, there's people who are driven ideologically kind of on one end of these issues or the other, and there's a vast swath of parents in the middle who, for reasons having nothing to do with this stuff, are pretty agitated about, for example, how their schools handled COVID, how long their schools came to let their kid back in when they saw they had relatives in other places in more conservative states, and their kids had got a whole extra year in classroom instruction because they lived in a very kind of a more progressive with strong teachers unions, and they kept kids out for another whole year. And some of those friends are really angry about that. And these are not people who have ideological access to ground in these issues. But when you're sounding themes of parental prerogatives and looking at what's best for kids and parents, these issues that are unrelated are coloring receptivity to those messages, I think, in a way that has political import for this year.
Question in the chat. Isn't there a distinction between teaching critical race theory versus just teaching the facts of American history that speak for themselves? Wouldn't just teaching American history be unimpeachably appropriate, even in a state with one of these CRT laws? I think, Emerson, maybe that gets back to your point about the chilling effect as well, and the vagueness point that does an employee have fair notice what is and is not a punishable offense, right?
Yeah, I mean, several of these laws mention CRT or the 1619 Project by name, but many of them don't, right? They actually just include this list of divisive concepts, which read, on their clear text, often prohibit the mere discussion of racism. And they're trying to prohibit not racism itself, but the discussion of racism because it's making folks feel uncomfortable. So I think, the idea that, there is one argument that we've gotten in response to our lawsuit is it doesn't cover any of those things. You're allowed to teach history. You're just not allowed to teach outwardly racist ideas. So we think that actually a decent way for us to lose in these lawsuits is for a judge to read these statutes quite narrowly and to say, of course, they cannot reach into the college classroom. It only is restricted to, the very narrowness. We don't think that that's the most honest reading of the law. We think that the text clearly covers a lot more than that. And the ways for us to lose, that's a pretty good way for us to lose, as long as it means that teachers understand that they're allowed to continue to teach accurate history. But the way that these laws are currently drafted, some of them have catch-all sort of clawback phrases where they say nothing in these laws shall prohibit the teaching of history or slavery or any other hard aspects of history. Notably, the Oklahoma law does not have such a phrase. We think that those were added later on to try to cover up some of the problems with the Oklahoma law. But I think, it begs the question, you may be able to teach that slavery existed by the terms of the law, but what if a student says, but why? Right? And then if you really want to talk about racism beyond just one person being spiteful towards another individual because of their race, but sort of on a more societal level, then in response to this very obvious question that a student could ask, you're going to quickly be in territory. Even if you say, oh, I'm not teaching CRT, you're going to very quickly be at least adjacent to territory that is directly targeted by these laws.
Question in the chat, could presenters share their views on states adopting parental bill of rights and how might that legislation impact this new wave of legal initiatives?
I was just typing out a response so I can answer
Go for
verbally. So at least here in Texas, the parental bill of rights proposal was brought up at a campaign event that Governor Abbott was hosting. So I think it'll be really interesting to see if or how the rhetoric changes when we're not in an election year. But a lot of what he brought up is actually already in code. So there's a lot of overlap there. But we have seen that a lot of groups are tapping into the momentum around this parental rights issue to renew their pushes for school choice or voucher-like legislation in Texas, which has historically not been successful. So I can post a link in the chat as to how we've looked at this issue here locally.
Please do. And Tom, there's actually a question about when you were talking about PICO and the law of school libraries that you referenced in ELA article. If you have that handy to share, and if not immediately, then that could be something that if it's publicly available and not paywall, that we could put in the along with the materials on the ABA website as well.
Yeah, it'll be. I think it'll be on the website because I did email it in to Allie. So I think it'll be there. Yeah.
Wonderful. Thanks. Someone asked a question. Interesting. Are their parents confusing what's happening in corporate DEI programs and their own discomfort with that, maybe in their own workplaces, with what happens in schools? And I think maybe Emerson mentioned earlier that some of these legislative initiatives do apply to private sector as well. And there have been some efforts to curb not just the teaching of DEI topics in schools, but also the use of DEI concepts and trainings as a mandatory workplace condition as well. Is one of these bleeding over into the other?
I think it's an interesting theory, hard to prove, but I think, in as much as we were talking about critical race theory standing in for anything that you don't like, if corporate DEI is something you don't like, I think it's definitely intended to be implicated. I think, just to, since this is the ABA, I'll get a little bit into the technical, reasoning for it. I mean, I think there's an idea that the First Amendment restricts government's ability to discriminate based on viewpoint, but it doesn't restrict the government's ability to make its own decisions and to express its own viewpoint, right? So the way that this plays out is that if the government or a government entity, whether it's the federal government or state government, wants to decide, we want to train our employees in a particular way and not in another way. We might think that that's horribly misguided and there may be some procedural problems with that, but in terms of a First Amendment right to receive information or viewpoint discrimination, when the government is training its own employees, there's nothing really to say about the First Amendment, right? You're not restricting private speech. You're just deciding what the government can and can't do. One of the ways in which the Trump executive order ran afoul of the First Amendment was that it applied to contractors, not just with government funds, but what they do on their own time. It said that if you contract with the government, you can't do DEI courses even with other funding, right? And that reached beyond the government directing its own resources and then reached into them directing private speech, right? So the government can say, you can't use our federal government funds to fund DEI. That's, again, just the government deciding how it's going to use its own money. Or they can say, we're not going to train our own employees that way. But when the government tries to say, you can't do this on your own time with entirely private resources and entirely private funding, that's, I think, a huge problem.
We're going to need to wrap it up. We're at time, but thank you so much to our panelists, to Talia Richman, to Tom Hutton, and to Emerson Sykes for this really rich and informative discussion. I will allow myself moderator prerogative to say, please subscribe to the Dallas Morning News or to the community newspaper of your choice. There are education beat writers like Talia Richman out there doing just truly, truly heroic work, bringing us information about these issues, sometimes at the risk of their own safety, and they are much, much deserving and in need of your support. The education, this webinar and many others are archived on the ABA's section of Civil Rights and Social Justice website. We provide webinars and resources for legal professionals and advocates in hopes that you'll find them useful in your work. If you can, please consider joining and becoming an active member of the ABA, and that link to join is ambar.org/CRSJ. So thank you again to our panelists. Thank you for attending. And for contributing your excellent questions. Best of luck to everybody in your work.